Have you been accused of refusing a DUI test and are unsure of the consequences? You're in the right place. In this video, I'll explain what a DUI refusal is, the penalties involved, and how to defend yourself. I'm Hieu, a DUI defense attorney in Orange County, California. I've helped many clients facing DUI refusal allegations, and I'm here to guide you through what to expect and how to fight back. If you're facing a DUI refusal charge, don't wait. Contact me today so we can discuss your case and start building your defense. Let's start by understanding what a DUI refusal is. When you're arrested for a DUI in California, you're required to submit to a chemical test, either a breath or blood test, under the state's implied consent law. Refusing to take this test after being lawfully arrested is considered a DUI refusal, and it carries additional penalties. These penalties for first offense could include a 1-year license suspension. This is a hard suspension, which means there's no restricted option. Additional penalties include fines, DUI education class, and possible jail time. The jail time associated with a refusal in court is 10 days in jail. For the second time, it's a 2-year suspension, and the third time is a 3-year suspension. It's important to know that you have the right to refuse field sobriety test or the preliminary alcohol screening test without penalty, as these occur before, and that's the key word, before an official DUI arrest. However, once you've been arrested, refusing the chemical test triggers the penalties we discussed. There are several ways to approach this DUI refusal issue. The first one is whether or not the arrest was unlawful. If the officer didn't have reasonable cause to stop or arrest you, the refusal may not hold up in court. The second one is failure to explain consequences. This is one of the most common ones, especially amongst cops in the cities as opposed to CHP, because cops in the city have other crimes that they have to worry about, such as domestic violence or more volatile crimes. Law enforcement here must inform you of the penalties for refusing a chemical test. If they fail to do so, it could be a valid defense. On top of that, there are other issues at play here as well. Medical or language barriers. If a medical condition or language barrier prevented you from understanding the request, this can be used as a defense. Test equipment issues is also at play. If the equipment for the test was unavailable or malfunctioning, the refusal may not be valid. It's important to have an attorney when dealing with the refusal case because of the at least 1-year license suspension. DUI refusal cases are complex and carry serious penalties. An experienced attorney can challenge the legality of your arrest, dispute whether the refusal was valid by subpoenaing the officer's body-worn camera. And then on top of that, they can negotiate with prosecutors to reduce or dismiss charges. Having a skilled attorney ensures your rights are protected every step. Remember, a DUI refusal charge is serious, but with the right defense, you can fight the penalties and protect your future. A refusal occurs when you refuse a chemical test after being lawfully arrested, and it carries penalties such as a license suspension and fines. Defenses include challenging the arrest, failure to explain the consequence, or barriers that prevent compliance. If you're facing a DUI refusal charge, contact me today. Let's work together to defend your case and protect your rights.